Welcome to OIG, UPIC and MFCU Investigations. What are they and how are they targeted against organizations? My name's Sean Weiss. I am the Vice President of Compliance for Doctors Management. I'm also a partner with the firm. Joining me today on this webinar is Eric Rubenstein, who is the Director of Litigation and Fraud, Waste, and Abuse Support with Advise Health. Eric is a retired. I almost slipped and said former. And Eric would have gotten mad because he thinks that means something nefarious transpired that led to his departure. So he'd rather say he's just old and that's why they let him go. Because
it's an interesting perspective, because I've got military friends that shy away from certain terminology when they talk about that, and it's always that, but they're always, don't call me X, call me former.
There you go, former. And that voice that you all just heard is another one of my good friends, Matt Lawhon, who serves as general counsel for a biotech company out of California. Matt is do you like former or X?
I certainly prefer former over X.
All right. So Matt's a former law enforcement professional. He was a police officer with the Dallas Police Force. He is a former UPIC investigator and a former MFCU investigator. Eric is, as I said, a retired Office of Inspector General special agent. We'll talk a little bit about both of their backgrounds as we move through our presentation today, but really this is a panel discussion. My job as the moderator is to pose some questions and then to simply get out of the way of these two gentlemen and let them share with you their knowledge of the inner workings of these organizations. What drives investigations against physicians, physician practices, non-physician practitioners, hospitals, healthcare organizations, irrespective of where you are in the country, what your specialty is? I think it comes down to, and I think the gentleman would probably agree with me on this, it's no longer a matter of if, it's simply a matter of when. So with that said, I think the place where I would like to start first is UPIC investigation. So, Matt, I'm going to start with you first because UPICs are ever present. They are a significant part of the current landscape. They've been a significant part of the landscape since they transitioned from zone program integrity contractors several years back. But even before that, there was a significant presence right with the ZPICs themselves. So my question to you is this: what is a UPIC?
Right. Yeah, and that's a really good question, because I think there's a great deal of confusion out in the provider community where they view the UPIC as simply just another Medicare contractor whose purpose is to identify overpayments and collect money. What needs to be understood is nefarious isn't necessarily the correct term. I guess it's nefarious if you're in the provider community, but really what the UPIC is an investigative agency who is really directed to identify fraud, waste, and abuse and develop cases for referrals to law enforcement, like Eric's old agency, right? HHS OIG, although they have the capability to refer to other law enforcement agencies depending on the direction that HHS wants to go in, right? It kind of started as the benefits integrity unit within the Medicare carriers themselves. And then that concept has evolved over the years from, a benefits integrity unit to a program safeguard contractor to a ZPIC to now a UPIC. And with each machination, CMS has kind of granted them broader access to information so that their investigations can be more complete, more thorough, and they can do a better job of identifying that potential fraud, waste, and abuse, and build stronger cases to refer to law enforcement.
So that's a great explanation of what a UPIC is. As a former investigator for a UPIC, can you talk about the type of activities that generate an investigation by one of these safeguard contractors?
Right. Yeah, absolutely. I think, the UPIC is much like any other investigative agency, right? Whether it be HHS OIG, whether it be FBI, whether it be my old outfit, the Medicaid Fraud Control Unit, they receive information that can be the predicate for an investigation from a multitude of sources. What I think makes the UPIC a little bit more unique is that within their statement of work, within their contract, right, and you can find their duties and responsibilities in the online manuals. I think it's 100-08 chapter 4, which is the program integrity manual for the online manual, right? That explains what they do. What's really interesting is that they are essentially mandated to utilize data analysis as a means of identifying these fraudulent trends. And they can do different types of data analysis, right? They can look at specific provider types. They can look at specific procedure codes, specific modifiers. They can drill down to a geographic location, right? And then each one of these analytical tools doesn't necessarily operate in a vacuum. They can build upon each other. And that's where the strength of this data comes out, right? You can take one data set and bounce it off another and really start to see the disparity or the improbability of the service that's being performed. So, their strength is their data analysis tools that they use to develop cases. But then, of course, they're going to get complaints from the provider patient community. They can get complaints from, not necessarily complaints, but because HHS OIG, and I'm sure Eric can speak more clearly to this, but HHS OIG runs a TIPS hotline. And that TIPS hotline gets flooded with information from the provider, the patient community, right? The general community at large. And because HHS is so shorthanded, a lot of times they'll funnel those HHS TIPS calls to the UPIC to develop and do the initial analysis on and see if there's any merit there. So again, it's and you can also have a proactive investigator, right? An investigator that pays attention to things going on out in the country, might see a news article that references a potential fraud scheme that's outside of their particular jurisdiction, and they might want to initiate some sort of data analysis or review on a similar type of service to see if that's if that's reflected in their region as well. So again, it's a multitude of reasons, with the emphasis being put on their data analysis capabilities.
So Eric, I want to drive a question over to you, because you and I have so many opportunities throughout the course of a week to have conversations about fraud, waste, and abuse, about different cases that we're both engaged in, investigations that we're working on, things of that nature. Talk about, because Matt really just lined it up beautifully. Talk about the critical importance of data analytics for a practice, the importance of them running utilization reports.
Yep.
How can they use that information to understand the potential for being a target of an investigation?
Well, first and foremost, one of the things that Matt said, which is probably the most important piece for the UPICs, is that as it went from benefit integrity within the carriers or the fiscal intermediaries to the PSCs, program safeguard contractors, to the ZPICs, to the UPICs, is that each time that occurred, there was a broadening of the geographic purview that organization that had that contract had it. And Matt's point really on data analytics is really this, is that as the organizations became fewer and they took over larger swaths of the country, it allowed them to have greater access to more data, which allowed them to see things that they wouldn't normally see. So, the great example I like to give on the data piece before we kind of get to this is when I was an agent in New York, Empire Medicare Services was the carrier. So they did Part B. They were also the Part A fiscal intermediary, but they had all of the boroughs except for Queens. Queens, New York, was with GHI, Group Health Incorporated. And that's at the fiscal intermediary or the carrier level. But at the time, benefit integrity was contained within whoever it was that had the carrier or the fiscal intermediary contract. So if you were working on a case, and this was common for us in New York, you were working on a case in which the provider had multiple offices, and one of them was in Queens and one of them was somewhere else. You had to go to two different places for data.
Yeah.
And the data wasn't data that looked the same. It wasn't like there was structured data as if, column A was this, column B was this. Your GHI data and your Empire Medicare Services data was different. And so as these things kind of morphed and as they morphed into what are now the ZPICs, so first, and then ultimately the UPICs, first and foremost, there's been a standardization of data, and that data all comes from the same repository now, so it doesn't really matter. But more importantly is that when an investigation is going on and you have potentially a border state or something like that, where you don't have what are now known as the MACs, because the Medicare administrative contractors are doing A and B, what you don't have anymore is them being the holders of the data. It's now in a central repository through CMS, and the UPICs now have that data. But getting now to that next piece, which is the importance of data. So just this morning, I did a presentation for the Columbus, Georgia chapter of the AAPC, and I spent a lot of time talking about this. And I do this a lot with my AAPC people because a lot of them are in revenue cycle management. A lot of them are in kind of compliance roles, and I say all the time that as a provider group, whether it's one doctor or 100 doctors, you should be running reports on what your utilization management is. And I didn't really know what the term utilization management was until I started with advising consulting, but it's basically a billing history. It's where is all of your money coming from? Where are your billings going, and where is your money coming from? And you need to look at that. Your cumulative billings tell you where your areas of, I will say, targeted or focused reviews are going to be. The OIG looks at things like quarterly trending, yearly trending, year-over-year trending. The commercial payers do that. Law enforcement is doing that. They're looking at the outliers. So, my great example is, everybody is now, modifier 25 is back on the radar. It never went off the radar, but now it's like, it's with a vengeance. It's back on the radar. And I have a provider group I'm doing work with where they were told by their billing company to add modifier 25 to every E&M. They're a new practice. The guys that run the practice they're emergency room doctors. It's an urgent care center. They've never done this before. And they are putting modifier 25 on every single claim, whether there is another service or not. And I said to them, look, at the end of the day, so here's where your analytics are important. Putting that modifier 25 on a claim like that is not going to have an effect on payment. You're still going to get paid what you're going to be paid. But what you've done is you've put yourself into a world where now you are going to be an outlier. And now if your E&Ms were not going to be subject to review, you've now put yourself on the radar where your E&Ms are now going to be subject to review. Meaning if you were billing for a lot of 99212s and 3s, and you weren't using modifier 25, you'd probably find that you're not anywhere on a bell curve or anything. But once you put modifier 25 on, you've now put yourself into another category where now you're going to be looked at relative to other people who are using modifier 25 with their E&Ms, and you're going to be outside that bell curve, which is now going to create a scenario. And that's what the OIG is doing. We would get data reports on a provider, for example, and it would be 8 or 10 tabs. It would be busiest day of the week, busiest day of the month, busiest day of the year. So we'd see the top number of claims. We would say the highest number of dollar claims in a given day, month, or year, quarterly trend, yearly, top codes with modifiers, most frequently used modifier. We would look at things greater than 12 hours or 14 hours, whatever the metric would be for in a given day with E&Ms. So these are,
right.
I just rattled off 8 or 10 metrics that the OIG is looking at. Now, keep in mind that when the OIG is looking at these metrics, they are typically only looking at these metrics initially for Medicare claims. Typically. Right. So,
well, hold on to that, because I want to get more into the OIG in just a few minutes. But I think your point is well taken on the different data points that practices, hospitals, health systems, irrespective of your size, irrespective of your geographic location, regardless of your specialty, these are universal metrics that should be looked at. These are identifiers that can point to an outlier or an aberrance. Matt, I want to go back to you for a minute. So as a former investigator, and I've heard a whole bunch of people say this to me. I got audited by a UPIC.
Right.
Okay.
Right.
Let's clear this up. Does a UPIC conduct audits?
So, I mean, that's a really good question. There are instances in where a UPIC is going to conduct an audit, right? I mean, an audit function is something that a UPIC can perform, but the vast majority of what they are doing, and again, I point to the program integrity manual, right, that spells out their responsibilities. It's very investigative centric, right? The UPIC is supposed to have offices that are in close proximity to a heat location, right? That tells you right then and there that they have a different relationship with law enforcement than your RAC or your MAC or any other type of Medicare contractor, right? They are, one of the metrics by which they're measured is the number of referrals that they submit to law enforcement, right? So it's how many cases they are investigating. They are looked at for what law enforcement is doing with those investigations, right? So it's not just, hey, we sent 50 referrals to law enforcement. Are those actionable by law enforcement, right? Are they cases that they look at, take, and run with, or is it something that they put on the back burner, right? And a UPIC is supposed to keep in constant contact with law enforcement. I think it's every 90 days. Eric, you'd probably know better or remember better. But every 90 days, that UPIC investigator has to reach out to law enforcement to see what they're doing with the case and how's it going, right?
That's right.
Your other contractors, Medicare contractors, are not doing that, do not have that type of relationship. So it's really, the UPIC is designed to investigate. And they're designed to investigate for the purpose of referring cases to law enforcement. That is their big kind of meat and potatoes of what they do. They have all these other ancillary functions. Auditing might be part of it. Medical review could be part of it, but all these kind of fall under that broader spectrum of an investigation with the purpose of getting it to law enforcement.
Great. Thank you for clearing that up. All right. So before we move on to our next topic, I want to say something and then, let both of you kind of weigh in on this. When a practice or a hospital or a DME provider receives a UPIC letter or UPIC notification of investigation, this is something that should not go onto the back burner.
Right.
This is something that needs to be dealt with in the same regards as receiving a civil investigative demand from the Department of Justice and or a request for information from the Office of Inspector General. Would that be a fair statement, Matt, Eric?
From my perspective, yeah, as an attorney that used to be in private practice and advise clients, I would say that if you got a letter from the UPIC, you should treat it similar to, say, a subpoena, in whatever context you were receiving a subpoena, right? Because these letters typically have time frames associated with them, so you have to be responsive within a certain time frame. And providers need to understand, if you don't respond within a certain time frame to that UPIC letter or demand for information, the UPIC has the authority to suspend your payments. That's the big stick that they carry, right? If you don't, fine, you don't want to give us your medical records, we're just going to cut off your payments and cut off a source of financial windfall for you, right? So, and then, and much like with a subpoena or a CID, you'd want to talk to counsel and advise them of what's going on, so that they can then come in and maybe help you deal with this.
And is it true? Is it true?
I was going to say, go ahead, John, sorry.
Is it true that in addition to suspending payments for a provider, that they could also revoke a provider's billing privileges when billing to Medicare or Medicaid?
Eric, you want to handle that? I mean, from my standpoint, I think it's always a possibility. Of course, with stuff like payment suspension or revocation of a number, they have to go through CMS's general counsel, right? So it's not just, hey, we flip a switch, this is what we're doing. They have to write it up and send it off to CMS general counsel, and CMS general counsel has to approve it and bless it.
Right. They have the authority to make that recommendation to CMS general counsel to revoke a provider.
Right.
Okay. Eric, go ahead. I'm sorry. I didn't mean to.
I was going to say, I would even take a step further. That when you receive these letters, the important piece of this puzzle is that the UPICs are working in a quasi-governmental capacity, right? So these are government contractors. They have a 5-year, typically a 5-year contract with CMS to administer these pieces of the program on behalf of CMS, right? So CMS doesn't pay claims on a day-to-day basis. There's a contractor that's known as the MAC that does that. CMS doesn't do the investigations. They have the UPICs and the MEDIC that do those things. And so when those letters are received, it's not really a request, like you must comply. There's statutory language that says you must comply. There's a condition of payment that says you must comply. As a participating provider to the Medicare program, you have to comply with these things. And so anything that you do that is inconsistent with the right thing to do, for lack of a better term, could result in you having a problem. And, like it could be, for example, if you doctor up your medical records and you send those to the UPIC, and the UPIC makes determinations on those records, and it's later learned that those records were fabricated, you could be charged with obstruction of a governmental audit. And I've done that before. There's a federal statute for that, where providers have these, documentation parties where they go, oh, we don't have this, and they create it. One of my favorite cases, one of the first cases I ever worked as an agent, was this ophthalmologist on Staten Island who had been doctoring records up for years. And when we did the search warrant, he had boxes and boxes of records in his closet where he would tell his staff, give me paper. He would handwrite his notes, and he would keep the original notes, and then he would make photocopies of his doctored notes. And so during the search warrant, we would find stacks of these patient records. So you get charged with that. That's, outside of the healthcare fraud piece, you get charged with the obstruction of a governmental audit, because the UPICs are working in a quasi-governmental manner. Now, if you choose to ignore this, then what winds up happening is, if you don't turn the records over by the date that they're due, or you turn over some records but not all records, well, then you've not complied. And in that audit, those claims are going to be denied. And if there's, for example, if 10 records are requested and you produced nothing or you ignored it, they're going to issue an overpayment letter for those 10 records. And then there's probably going to be a referral made over to OIG. I think in the broadest sense, the UPIC's role is to resolve, to the best of their abilities, allegations of fraud, waste, and abuse. And so a resolution of that allegation could be an overpayment letter, and then it's done, right? It's a waste abuse, all the way through some indicias of fraud, where then it goes as a referral to OIG. Now, always understand that at the OIG level, and really to an extent, I think at the UPIC level, there is no discerning of fraud, waste, or abuse, right? U.S. attorneys' offices, I think, typically are the ones that make that. No, as an agent, I don't think I ever looked and said, "Ooh, I think this is fraud. Ooh, I think this is waste or abuse." I would make a presentation to the U.S. Attorney's Office and go, I don't think that this rises up to the criminal level. Maybe this should be something that's handled on the civil level, or an AUSA might say that. And then they're, looking back now, I think I was sort of intuitively coming up with what I thought was fraud versus waste and abuse. But I don't think that there's sort of this focus on doing that. On the commercial side of the world, the commercial payers will break up fraud versus waste and abuse because they have payment integrity and then the SIU. But, I think, to Matt's point, when you get these UPIC letters, you should never ignore them. It's not just somebody asking for this. It really is a government request. And B, you really got to get your ducks in a row on this, and take a look and see what's going on, and that likely does include having having a healthcare attorney come in and take a look at this.
Yep. So I want to go ahead and transition to our next topic, and this one is a bit different, right? Because we're always talking about Medicare, right? We talk all about the commercial payers, but what doesn't get talked about a lot is Medicaid. And I'm not sure why, because Medicaid is a significant payer when it comes to healthcare services. Now, again, Matt, I want to start with you because your work experience is fascinating to me, right? Because if I'm not mistaken, and I know we're friends, and I know you're going to correct me if I'm wrong. But I believe you work.
Like, that sounds much better than my real background. Let's go with that.
If I'm not mistaken, if I remember correctly, you worked for one of the very first Medicaid fraud control units in the state of Texas, and prior to him becoming governor of the state of Texas, Abbott was the attorney general for the state of Texas.
Correct.
And if I'm not, I'll tell you what, rather than me keep saying, if I'm not mistaken, why don't you tell us about your involvement and engagement and your evolution in that process of creating the Medicaid control fraud unit, and really, what is it?
Yeah, so I mean, the Medicaid fraud control unit, at least from my standpoint, has always existed, right? It's a requirement for states to have this. When I was actually with the PSC, it was Tri-Centurion. I think both of y'all are old enough to remember, or actually have done work with Tri-Centurion. Oh, Eric, you know the name. I actually did work where I worked with some Mafuku investigators, and that was under now Senator John Cornyn. He was the Attorney General, and then Abbott came in shortly after that, or when Abbott came in and took over as Attorney General. At the time, the Medicaid fraud control unit was housed solely in Austin, Texas, and I think it was a unit of about 35 people. And what Abbott actually did a good job of is looking at this unit and saying, hey, the return on investment for this small unit is actually really good. What if we expand this across the state, because we're a big state and we have lots of Medicaid clients? I think our return on investment would grow exponentially. So based on my law enforcement background with DPD and my healthcare fraud experience with the Medicare contractor, I got picked up in that expansion, where it expanded to offices in Houston, Dallas, Lubbock, El Paso, San Antonio, Corpus Christi, the Valley, which is the southern tip of Texas. It's commonly referred to as the Valley. They had an office down there, and I got picked up into that. And so we were very similar to HHS OIG. We had law enforcement investigators. We had fraud. We had auditors that were all civilian, but supplemented and supported the law enforcement functions. Right, they were the ones that did all the math for our overpayment calculations or our damage calculations. Right, for our fraud cases. And we had assistant attorney generals that we could go to and consult with during the course of our investigations. Some of these assistant attorney generals are also cross-designated as what we refer to as SAUSAs, Special Assistant United States Attorneys. So they were prosecutors at the federal level, even though they were attorney generals, assistant attorney generals. And so we would receive complaints, like we talked about earlier, from a multitude of various sources, and develop those cases and present them for prosecution.
Now, were there any inherent differences in the Medicaid fraud control unit work that you did versus, what the focus was from a UPIC perspective?
No, essentially, as a UPIC investigator and transitioning to a MFCU criminal investigator, I essentially functioned fairly similarly, with the differences being what I was allowed to do as a law enforcement officer with MFCU versus a senior fraud investigator with the Medicare contract. Right, so I had freedom to submit or request subpoenas from a grand jury. I had the authority to get FinCEN reports that were very useful. So I just had more toys to play with and greater authority, but the core function of doing data analysis, reviewing documents, interviewing people was essentially the same.
Got it. Let me ask you both this question, Eric. I'll ask you first, and you may have the same answer. I don't know. Do you believe that fraud, waste, and abuse is more prevalent in the Medicaid system or in the Medicare system?
Wow, that's a great question. So I think the issue is that I think it's more from a dollars perspective. I think we'd have to look at some of the statistics to see who gets dinged more. Obviously, Medicare pays more than Medicaid, so one would suspect that the dollars would be higher in Medicare. However, that could be negated by the fact that the prevalence of fraud on the Medicaid side is a lot broader, right? So, the thing about Medicaid fraud is that there were things that Medicaid covers and things that Medicaid has covered that weren't covered by Medicare. And so some of the cost differentiators between reimbursement can easily be negated by the fact that, for example, Medicaid covers certain types of transportation and personal care services, right? Wheelchairs and livery type services and homemakers and those kind of services that Medicare doesn't cover. So from a dollars perspective, it can be very similar. I have to go back and look at some of the stats because they're published. Yep. I think that there's a broader prevalence of Medicaid fraud than there is Medicare fraud, only because there are so many more things that Medicaid covers in which it can stay within that dirty underbelly, right? So the DME world, that stuff rises to the top. The genetic testing rises to the top because of the dollars. But to what extent, for example, is the home health fraud, right? We know that home health fraud on the Medicare side is very prevalent. But then you get to these personal care services and, on the state Medicaid side, you have this thing now, the EVV, the electronic visit verification, which, has had some issues, on getting that done. And so I think the issue, it's a little bit of an apples to oranges discussion because there are just differences in what the frauds are that can be perpetuated. But I think from a dollars perspective, we're seeing that Medicaid dollars are being, the fraud on the Medicaid side is substantially more than it is on the Medicare side, just because it's more broadly unchecked than it is on the Medicare side. And also keep in mind that, that when Matt was working for Texas Mafuku, a large portion of Mafuku's funding comes from HHS, from OIG and from HHS. And so in a year where there's a lean budget, is Matt able to work with, does he have 20 coworkers, or are they doing reductions in force when people that worked with the Mafuku investigators in any state retire? Are they not backfilling those positions? There are states, I think it's Vermont maybe, or Maine, 2 or 3 Mafuku investigators for the whole state. And so if one of them leaves, do they say, hey, that's a line item we can't even afford to pay anymore?
Right. So Matt, let me ask you, because you've been on both sides. Do you think the fraud is more prevalent in Medicaid or in Medicare, or do you think, along the same lines as to Eric's thought process and explanation?
I think Eric's explanation I'm pretty aligned with. I mean, there are things that Medicaid pays for that Medicare doesn't. Medicare is going to be primary payer on if you have dual eligible beneficiaries, which we had a lot in Texas, right? So Medicare is going to be primary, Medicaid's going to cover that 20%, right? They're secondary. So it's that balancing act of, okay, Medicare probably pays more, but Medicaid covers more things, right? So Medicaid pretty much covers everything that Medicare does, but also some other stuff. I think really, to me, what it boils down to is that both Medicare and Medicaid are ripe targets for fraud, because under the Social Security Act, right, both programs have to pay for all medically necessary services. So it essentially operates on the honor system. You're a provider that has a credential with either program, you're submitting a claim that's a clean claim on a Medicare beneficiary or Medicaid client. Your diagnosis code matches okay with your CPT code. You're going to submit that. It's clean. It's going to be paid, right? Where some of these from the commercial side, they might have some upfront edits that make you jump through some hoops before that claim is, so they can catch stuff. They can deny it before it gets paid out, right? So I think I would say, if I'm trying to determine, it's too hard for me to determine and sit here and tell you today, well, Medicaid gets fleeced more for reasons enumerated by Eric. Medicare gets fleeced more for reasons enumerated by Eric, right? I think from my perspective, it's both programs are fleeced fairly healthily, just because of the way they were enacted under the Social Security Act.
Yeah, I think that's a great explanation. You and I, Eric, have a mutual friend who's a former Medicaid prosecutor out of New York, Riz Dagley. And, it's interesting because you and I think we're seeing more and more cases now involving Medicaid. At least I am. I don't know if it's because, there's been more of a focus on the Medicaid program. But, it's interesting. We were talking about a statistic a couple of weeks ago where, apparently the Medicare trust fund has now been pushed back as far as solvency, back to like 2038 now?
Oh, I don't think it's that much, but a couple of years.
Right.
Well, it's beyond the
maybe.
2020. No, it was somewhere in the 2030s, because they were, and I know you're going to look it up and you're going to prove me wrong, as you like to do, which is it's okay with me. I got
He's already typing away on the computer.
I know. He's gone to Dr. Google to get his diagnosis.
2020. I have a PhD from Dr. 2026.
Okay. My understanding is that you're talking about
a little bit is Social Security got pushed out into the 2030s.
Oh, that's what it is. Thank you. See, once again, I know. Take your curtsy. You deserve it. Okay. So, Eric, and Matt, before I get into a discussion about regulation versus sub-regulatory guidance documents, and really their impact on things like local coverage determinations and the difference between national coverage determination, I want to talk and come back to, your old stomping grounds for a few moments, Eric, if we can. Again, you started to talk about, specific points that, or metrics that providers and healthcare organizations should be looking at on a regular basis. I think you gave 8 or 9 points, but let's talk about OIG, because you and I are involved in a few right now with OSIG. We have other clients that are in the process of self-disclosure protocols. And I think it's really interesting to get your perspective as a retired agent from what you used to see to what we're seeing now in the litigation landscape. Because coming off of a call not too long ago, it was a pretty aggressive stance by OIG, and I think that actually kind of took you by surprise a little bit, being a former agent. So let me wind you up a little bit and kind of let you go, and let's see where it takes us.
Yeah, it's I think the problem, I think, is that as time has now gone on, there's a need to be more aggressive in the manner in which healthcare fraud, waste, and abuse cases are being handled. So we, all three of us are active on LinkedIn, you and I, Sean, in particular. And there's constantly, we read press releases in which providers are being prosecuted for multi-million-dollar frauds, and the courts are not treating these losses the way that I think the general public would like them to be treated, right? We see these providers who are getting away with stealing millions of dollars, and they're getting 18-month sentences, year-and-a-day sentences, things of that sort. And there's obviously, there's a lot of things that we don't see. And, Matt and I have talked about this ad nauseum on loss amounts and this and that, but at the end of the day, we only see what's in the press release. We only know what the press release tells us. We don't know what backstories there are. We don't know any of these other things. And so there's, I think, this knee-jerk reaction to that, of that it's just unfair and what have you. But there's definitely a more aggressive posture in the prosecution piece of it, right? The investigative piece, because we're seeing this. And in particular, we're seeing this with instances where a study is done by OIG. We're working on something right now where OIG did a study. One of the other components, people don't always know there's multiple components to the OIG. There's OSIG, which is what we're talking about, Office of Counsel to the Inspector General. There's Office of Audit Services, Office of Evaluation and Inspection, where they're doing analyses of things. We'll just use the general term. And then where I was, which is the Office of Investigations, I used to always say the Office of Investigations were where the badges and guns were. The Office of Evaluation and Inspection was where all the data scientists were and the social scientists. And the Office of Audit Services is where all the accountants are. And what's happening now is Office of Audit Services, OAS, and Office of Evaluation and Inspection, OE&I, they're doing analyses, they're doing reviews, they're identifying weaknesses in the program, and the Office of Counsel to the Inspector General is picking up on those, and then taking these very strict positions on this. And I think the matter that we were just talking, kind of alluding to, is this notion of strict liability, of we're not going to negotiate with you. You violated this rule. This is the rule. This is what it said. It doesn't matter if the rule said something different now, because it doesn't matter. It matters that at the time, this is what the rule was. And I think, Matt, please chime in this. From a jury appeal perspective, if a person is being tried for something, criminally, civilly, doesn't matter, and the rule was this, and when you got charged under that rule, but today the rule is different, and you actually would have some latitude in it, that is terrible jury appeal, right? Because somebody at some point took a look and said, hey, maybe we're taking a draconian approach to this, or maybe we need to rethink how strictly we should be viewing this. And that should be part of that metric. You know what I mean? Like, I get it, in an administrative case, there's no jury, but that still doesn't absolve the common sense approach that's out there.
Yeah, and you're right. I think that does have impact on, quote unquote jury appeal. Somebody will always come back and say, well, if they wanted to make this retroactive, they had that capability and they could use that language. So their intent was to keep that conduct criminal or liable, even though we've rectified this discrepancy and made it correct, right? But again, to your original point, yeah, if you're going to try to push forward on this, that would be one of those cases as an investigator I would look into and maybe have a conversation with the prosecutor I was working with. Say, what are your thoughts? Right. How aggressive do you want to be? Because here's the pitfalls that I see for you.
Well, the interesting piece of that is that on these strict liability matters, which are really just, you can only do it this many times, anything more than that you can't do. Right. There is no investigator involved. There is no, it's an attorney from OIG. And what they're really doing is they're saying, okay, the rule says this, you did this plus that, and therefore you violated the rule. And so we don't care about what any of the additional, or really any of the facts and circumstances are. This is under this strict liability. You were only allowed to do this, and you did more than this, and therefore you're being held accountable for this. There's none of the other factors in there that come into play. And I get it, I get it. In the thing that's always interesting is that in these studies that are done by, for example, OE&I, those are really studies that are being done to understand whether or not CMS did what it was supposed to do, right? So one of the things that OE&I is doing is empirically testing the veracity of the program, right? So they're saying, if the rule is that you can't do more than 2 pinpricks in someone's eye in a rolling 12-month period,
you could have used a different example, but okay, we'll go with 2 pinpricks in somebody's eye. Cool.
And you did 3 pinpricks.
I know the folks can't see us, but I think Matt and I both cringed at the same time.
Don't be afraid. Don't be afraid. And your healthcare provider did 3 pinpricks during that rolling 12-month period, and the program paid for it. OE&I is going to say, hey, there was an overpayment. CMS allowed payments of X number of dollars to go because it didn't enforce its policy, or the MACs didn't enforce their policy on only allowing 2 pinpricks in a patient's eye in a rolling 12-month period. The problem then becomes that it's not just that CMS needs to tighten up the program, but then all of the providers that got scooped up in that study are now the collateral damage for that study, right? And are held to what amounts to, and this is where Sean and I and the lawyer for this one practice we're dealing with have argued, is that you are holding these particular providers at a different standard than other providers, because what you've done is you've said, okay, Dr. Matt Lawhon, you got caught up in this study and you owe $200,000. It's really $100,000, but we're doing double damages because it's a CMP case. But Dr. Sean Weiss, the MAC has told you to self-audit and fix your problem. And so you've got this differentiator where providers that have done the same thing are being treated differently, merely because one provider got caught up in the OE&I study, or however they got caught up, versus another provider. And so in these strict liability cases, there's zero, like I can tell you, we just had this happen, zero wiggle room. Like they don't even want to negotiate for a multiplier under double damages unless we provide financial disclosure statements, which, as you know, is something that you really don't want to do, because what they'll say is, okay, maybe you can't pay that $200,000 back in a year or 2 years, but you could pay it back over 5 years. And if you were looking to reduce your financial liability through a time calculation, someone is going to come back and say, oh, you could pay this, it's just going to take you longer to do it.
Right.
So you don't want to ever get to that. And that's really become one of the fights that Sean and I and one of the attorneys that we're working with, that's been one of the fights that we've been having now is, not doing these financial disclosures because of that fear. And then the other half is continuing to try to find ways to get the Office of Counsel to the Inspector General to wiggle. The problem is that they don't want to wiggle because they don't want to set a bad precedent of treating a provider differently than they're treating other providers. So it's really it's a rock and a hard place on these.
Yeah, it really is, and that brings me to the next conversation. So, and this will probably be our final conversation of this roundtable. So, regulations, Matt. Regulations are those that are promulgated into the law. Those are they're subject to the comment period. They're put into law by Congress, by legislature.
Right.
Sub-regulatory guidance documents are not legally binding, right? Because they're not put through the formal rulemaking process. Now, one of those sub-regulatory documents would be considered an LCD. Okay.
Right.
So, so with LCDs, because this goes back to Eric in the last thing that you were saying, which is, in these strict liability cases, OIG in this case is basically looking at it and saying, they said that you could do X, you did Y, you were overpaid, you owe us money back. Now, the interesting thing in this case was being told that we don't care about medical necessity because we would expect that everything you bill to the government is medically necessary. Otherwise, you wouldn't do it.
Right. Can
you talk about the importance for our listeners, for the NamUs members, to understand what a sub-regulatory guidance document really is, and how does that differ from something, say, a national coverage determination?
Well, I don't know that an LCD necessarily differs from an NCD. Right. I think those are really both kind of function as guidance documents, where the difference is what you talked about, a regulation that was promulgated via the Administrative Practices Act, right? That for some reason, somebody thought it was a good idea to absolve Congress of their lawmaking responsibilities, place that in the administrative agencies under the executive branch of government and say, hey, you can go ahead, executive branch, through your administrative agencies, make laws, right? So, but in order to do that, it has to go through notice and comment, right? And that's how you get all these rules in the Code of Federal Regulations, right? The theoretically speaking, an NCD and LCD should be predicated on some sort of statutory authority. And I think y'all have had conversations on a case that came out, last year, Alina, that got into this. You were going to say something.
Yeah. Azar v. Alina Health Systems.
Yeah,
right. The 2019 Supreme Court ruling.
Right. And what that case was really saying is, okay, CMS, HHS, you've created this new payment methodology. And because it's a new payment methodology, it doesn't fall within this LCD NCD concept. It's an actual new rule that should have been subject to notice and comment. But again, most of the LCDs that I review, NCDs that I review, always have that kind of citation to the Code of Federal Regulations that state, this is the source for this documentation. Because if you think of it just from the common sense standpoint of a guidance document really just elucidates your stance on what the policy is, right? So you have your policy and you have your guidance document that in kind of clear language says, this is how we interpret this regulation, right? It not creating a new policy, not creating a new payment, not creating new rights under this LCD. Is just saying, okay, 42 CFR 410-.32 says this, or is this LCD, this explains our understanding of how that rule reads, right? And so when you kind of use those LCDs, NCDs to create a new right or create a new policy, that's when people start to get into trouble.
Got it. All right, Eric, let me go ahead and give you the last word today. Anything that you want to specifically speak to with regard to the UPIC process, the MFCU process, OIG process, regulations versus sub-regulatory guidance documents? Floor is yours, my friend.
Yeah, I just think the closing argument on this is that, look, if you're a provider that's intent on committing fraud, none of what we've said for the past hour actually matters, because you don't care about data analytics, you don't care about getting subpoenas, you don't care about any of this. What you're going to do is when Uncle Sam comes, you're going to get on a jet ski with a lot of food and a lot of water and an extra bladder for gas, and you're going to hit the road. And you're going to go south because that's what you're going to do. So if you're committing fraud, you don't care about the things that we talked about. If you're in that waste abuse piece, there's a combination of things that you might care about. And you might care about, well, hey, I'm in this waste abuse piece, but I didn't really think I was, or I didn't mean to, or I'm not looking to get myself into the fraud piece because I don't have enough money to buy a jet ski, and I don't want to, to do that. And not really the case, but you do not wear orange when you're in federal prison. It is a tan khaki. So you want to stay away from that, right? So if you're committing fraud, that's, you don't care about these things. If you're in the waste abuse, you care. And that's where that data analytics piece comes into play. Understand where the government is going based upon your own data.
All right. So the nod to jet skis, just for our NamUs members who are hanging out with us today.
That may very well have jet skis because they might be successful at what they do. So let's not castigate them for having jet skis and assert that because they have jet skis that they have committed fraud. That's my disclaimer as the NamUs attorney for everybody listening, right? If you have a jet ski, we believe you did not commit fraud, despite what my good friend Eric just said.
Such a defense lawyer. It's amazing. So, I love it.
that was very good, Matt. Very talented. So for those of you who are wondering what we're talking about, there's a provider out of Miami, Florida, go figure, who was under indictment and owes a significant amount of money. He is a Cuban immigrant, and in a matter of just a couple of months, he was paid about $2.5 million for supplies and or services that he never rendered. And in making his escape from the U.S., his jet ski broke down about 90 miles outside of Cuba. and he was transporting another individual on the back of the jet ski who is known as a human trafficker. And they had extensive food rations, water bottles, special fuel cells, which indicated that they were on a long journey through the Gulf Stream that runs down, along the eastern seaboard, if you will. And they were captured by the Coast Guard when their jet ski broke down. So the lesson here is, if you're going to make an escape on a jet ski, at least have it service first before you put it in the water. All right.
Get the check engine light checked.
That's right.
That's right. Get the check engine light checked. All right. So to all of our NamUs members who were tuning in, logging on, and hanging out with my good friends Matt Lawhon and Eric Rubenstein, I want to say thank you so much for spending some time with us today. We hope that this roundtable panel discussion on UPICs, MFCU, OIG regulations, and sub-regulatory guidance documents will resonate with you. We hope that we have had an opportunity to provide you with some solid insights from former and retired law enforcement professionals. These guys are truly experts. They are masters of their craft. Guys, I feel like I've known you forever, even though it's only been, about a year and a half, almost 2 years that I've really, truly known you guys. And I will say it's always a pleasure. It's a privilege to hang out with you. I learn something new each and every single time. I think our members are going to be extremely appreciative of the information provided today. And with that, gentlemen, say goodbye.
Bye, everybody.
Bye, everybody.
All right, everybody. Take care. We'll see you again on another NamUs webinar.